So I've started recording tonight's tutorial to enable those who will not be able to make it to then watch the recording later on. So thanks everyone for joining tonight's tutorial. We could probably begin. So tonight we're talking about sources of international law. But before we discuss the topic, I'm hoping to spend a few minutes on the course assessments. Would anyone have any particular question about the course assessments? Because I actually had a number of questions that were raised in one of my, in the other course which I'm handling, which is administrative law. So there were a few questions about the assessments. And I wonder if some of you may have questions about the assessments for this course, because the assessment regime is actually similar. So the assessments that we have for public, international, and human rights law are actually similar to those in administrative law. So perhaps if you might have any question about the assessments, I'd be very happy to answer them. Questions, comments? And I noticed that Samantha is actually also taking up public, international, and human rights law. So if there are no questions, let me just give an overview about the assessments and why they are different. Again, just to provide some guidance to those who actually are still trying to grapple with the distinction among the three assessments. Okay, so let's begin with the group discussion, both in terms of the group presentation as well as the one in the Moodle forum. So as far as these two assessments are concerned, the one for the Moodle discussion as well as the group presentation, you will observe that there, in relation to the group Moodle discussion in particular, there is a word count limit of about, I think it's 500 to 600 words. And as far as the Moodle discussion is concerned, you're meant to provide a factual background of the problem, event, or issue, and then come up with 3 discussion questions, which are intended to generate a discussion among your peers, or an interaction or comments from your peers. Now, you will notice, therefore, that that particular task is different from the task involved in the group Zoom presentation, because the Zoom group presentation involves an oral presentation. So the group Zoom presentation looks at the way that you're able to present your problem. The one for the Moodle discussion is more of written text based, as opposed to the one for the oral presentation. And obviously, there is a difference as well in terms of time constraints. There is a time constraint as far as the Zoom presentation is concerned, because you're only given 10 minutes. So your job is to be able to present the factual information orally within the time frame, as well as be able to then answer questions pertaining to the problem that event or issue that you've identified. The way you're being assessed in relation to the Moodle discussion forums is actually not only just your ability to frame your question, frame your problem, and then state your questions, but also in terms of your ability to engage with your peers once they come up with questions or comments or answers, and whether or not you're able to respond to these questions or comments timely. So you're being, in terms of the marking criteria, therefore, the marking criteria are actually quite different. Now, how do we compare the group presentation from the web page? Again, there is a huge difference. First, the Moodle discussion, for example, obviously, the intended audience would be your peers, your classmates. As far as the web page is concerned, your intended audience is the broader public who are not taking up law, who may have who will obviously have no knowledge about administrative law, rather public international law, and yet you are hoping that because of the problems about public international human rights law that you are presenting in a web page, that will then motivate the public in general to try to grapple with or engage with a public international human rights law problem, event, or issue. So you've got differences in terms of audience. You will also notice that there's a difference in terms of the word count. The word count is about, I think, you're going to have to look at the course profile. I think it's about 1,200 words for the written text of the web page, as opposed to 500 to 600 words for the Moodle discussion forums. There's a distinction. So in other words, you can say more as far as the web page is concerned. So in other words, because you will be saying more in the web page, it is understood that your discussion and coverage of a specific topic or a problem will actually be more detailed. Okay. Thirdly, there's a difference also, because unlike the one for the Moodle discussion, the one about the web page requires you to actually talk about the significance or importance of the problem, event, or issue that you are trying to examine. So again, you are assessed on a different dimension. As far as the web page as well is concerned, you're not limited to written text. You can actually use videos or even images, and you are expected to. Because what you're hoping to do is to be able to generate an interest among the public, among those who have no knowledge about public international law. So images of people being killed, images of boat refugees who are left to fend for themselves in the high seas, or images of bombings made either by the United States or even Australian aircraft, which may end up killing civilians in Syria. These are images that can actually evoke sympathy or evoke an interest in the public. You don't have that opportunity in the Moodle discussions. You will also notice that in terms of the marking criteria, 30% of the marks for the web page assessment relates to the aesthetic appeal as well as the functionality of your web page. So there is again a different marking criteria for the web page as opposed to the Moodle discussion. So what happens therefore, if you'll notice, is that although you are dealing with the same problem, event, or issue, you're actually being assessed across different dimensions. So as an example, if you speak of the Miss Universe, if that is something that's relevant to you, because the Miss Universe beauty pageant, for example, is owned by Donald Trump, you will notice that the person who wins the Miss Universe contest will be assessed not only in terms of beauty, but in terms of intelligence, I think, in terms of the way that she answers questions. And she could be assessed in terms of her ability to be friends with other people. I think there are also dimensions where they're being assessed in terms of the kind of gown that they're wearing. So in other words, the way that a person, the contestant, for example, is being assessed or evaluated is actually across different dimensions. That is happening too with the different assessments that we have. You are being assessed across different dimensions, and the assessment tasks obviously are different. In relation to the individual research essay, the crucial point there is that the research essay has an even higher word count limit, which again enables you to have a more thorough discussion or background of the problem, event, or issue. But more importantly, a key task of the research essay is your ability to apply the rules to the facts. You are not assessed on that criterion in relation to the other two assessments, but you are being assessed particularly in relation to your ability to apply the rules to the facts as far as the research essay is concerned. So if you examine the assessments in relation to the group discussions as well as the web page, you are not allowed, you're not actually permitted to try to apply the rules to the facts. So application, the ability to apply the rules to the facts, is something that you are not being assessed on in relation to the web page and group discussion assessments. So you're being assessed across different dimensions. But if there is a common theme across all of these assessments. It is the fact that all these assessments revolve around the same central problem, event, or issue that you have identified. And obviously, while it is helpful to you to be working in a group environment for the first two assessments, ultimately, you're also being assessed on your individual ability to write a research essay in the final assessment. So for the first two assessments, for example, you are being marked according to your ability to be able to deal with your group mates. There is no such marking criterion in relation to the research essay. And what we need to remember is that the ability to work in a team is actually a valued graduate attribute of a graduate of CQUni. So that's why we have that. Okay, questions, comments about the assessments? Is it a web page or a website? Wait. Rice, in relation to that question, are you trying to make a distinction between a web page and a website? Or are you just saying that the web page and the website are the same? I'm not sure what you mean by that. Ah, okay. It actually depends on you. I mean, if you feel that a single static, the interactivity, there are many kinds of interactivity. I would assume that, are you talking of hyperlinks, for example? So if it's possible for you to come up with a single web page, which is so a web page is necessarily, I think, a website. But I think what you're suggesting is that you can have a web page with multiple pages, with multiple web pages. But obviously, a web page necessarily has to be a website. So your question is it possible to come up with a website that comprises of a single web page? I think the answer is yes. Although, if you're looking at aesthetics and functionality, it will actually be helpful if a website has multiple buttons. So one part talks about, for example, what the problem is. The other part talks about what the significance is. It's easier with the buttons there. The other one talks about the rules. Instead of scrolling down. Okay, so I would think it's possible for a single website to just have a single page, but in terms of its aesthetics, functionality, friendliness to readers, I think I would probably mark it less. And I can't see, I don't think you'll typically see a website with a single web page. Not even blogs have that. Blogs would have multiple pages. So I would argue that your website should have several buttons, and because there are several buttons, is that the correct word there? You know, like home, contact, you know, that type of thing. Each of those buttons up there will actually lead to a different web page. Okay, questions, comments? Thank you, Rice, for raising that. Yeah, the menu buttons, yes. So I've actually created my own website. I've got my own, if you notice, and it's on the Moodle page. Questions? None? So we're happy to proceed.
Hi, Manjo.
Yes.
With the module,
yes.
With the module, the Zoom presentation rather, is it individual group member that will be presenting, or we have to nominate one person to represent the group?
It depends on the group. The only requirement is that you're only given 10 minutes. So I'm not sure if all 5 students, assuming there are 5 in a group, I don't know if all 5 of them will have an opportunity to actually make a presentation.
Okay, so I will take your answer to be nominate one person to represent.
Yeah, I would think you'd nominate 2 or 3. I mean, so from Samantha, you can each have 2.5 minutes. I mean, it's up to you. I don't see any reason why you can't evenly spread it among the group members. It's always possible. Why not? Or you can always say that, you know, somebody does this, and then if there are questions, it will be some other students who will be given the task of answering those questions. So I leave that to the group.
All right, thanks.
Mm-hmm. Questions? None? So we can proceed. Okay, thank you. And again, as a reminder, I would strongly encourage that a group at the start should have at least 5. Because if you're dealing with only 3 and one of them backs out, you go back to square one. Okay, so if you have 5, you have a buffer there, assuming that somebody decides not to pursue the course, you'd end up with at least 4. So that is my strong suggestion. At the very start, try to have at least 5 members. Okay, so moving on. After studying this topic, you should be able to discuss and explain the legal basis for the binding character of international law and sources of international law. And as a backdrop to provide the context, if there is an international law dispute, you obviously need an international tribunal ought to be able to adjudicate that dispute or that international controversy on the basis of some law, right? Because in the absence of a law on which a decision can be made, how is an international tribunal meant, whether it's the International Court of Justice or some other international tribunal, which can be created by the parties on the basis, for example, of a treaty provision? How else can an international tribunal make a decision if it doesn't know what law to apply? Now, in the domestic context, courts easily know what the law is, either because they resort to laws passed by the Commonwealth Parliament. They may examine subordinate legislation in terms of the regulations passed by the executive. They can also have recourse to judicial decisions on the basis of stare decisis. But more importantly, on the part of common law jurisdictions, the fact that the law may be silent on a matter or on an actual controversy between parties will not prevent a court from making a decision. If need be, it will create the law. And that is in fact what has happened in the past. Oftentimes, especially in the 1500s or the 1600s, there would be a dispute between parties and the law is silent on that dispute. What then will the court do? Will the court refuse to entertain a suit because there is no applicable law? In common law countries, the courts will make a decision. If need be, they will make the law. That's why we say that as far as common law, the common law jurisdiction is concerned, we have what is known as judge-made law. So if the Commonwealth Parliament, for example, has failed to pass a law on a particular subject or on a particular set of facts, the courts will intervene by coming up with the law itself. So that's called judge-made law. Now, you distinguish this from civil law jurisdictions where what actually happens is that the respective parliaments will come up with what are known as codes. So you'll have the civil code, you will have the criminal code, you might even have the administrative code, which actually provides all these provisions that will then be applicable to various potential legal controversies. So that is the beauty of domestic systems, because courts can easily identify what the sources of law are, which they can then apply in arriving apply to the facts in order for a court to arrive at a decision. The problem, however, in international law is who makes the law? Where do we find the law? So is it the United Nations, for example, the United Nations General Assembly that makes the law? Is it the UN Security Council that makes the law? Because note, in the international legal order, there is no world parliament. Okay, so it's crucial that we know that as far as the international tribunals are concerned, when they are faced with, or before them, if before them is an international dispute, they'd like to know what exactly are the sources of law so that they know what international law to apply. Now, so from Samantha, for example, an example of a source of law will be international custom. So that's good. So tonight, you should be able to discuss and explain the legal basis for the binding character of international law and sources of international law. So let's proceed with discussion question 1. And this particular question is taken from the book by Abbas. Okay, so I'm going to read the question. Kandoma and Rutamu are 2 neighboring coastal states along which the river Hope runs. Hope is densely populated by a rare fish that is of high commercial value. From time immemorial, both states have fished in this river without any problem. But due to the narrowness of the river, the states developed, so the 2 states developed a system whereby whenever one state was fishing, The other would wait a distance away until the first had left. On one particular occasion, a vessel from Kandoma was fishing when a vessel from Rutamu approached. The latter vessel refused to halt. Instead, it progressed until it got entangled at the mouth of the River Hope. Unaware, the captain of the Kandoman vessel collided with the Rutamuan vessel, killing 3 members of his crew, although there were no casualties aboard the Rutamuan vessel. When the Rutamuan vessel reached Kandoman shores, the Kandoman Revolutionary Guard promptly arrested the vessel's captain for trial in Kandoma. Rutamu objected to this proposed trial and claimed, in objection to Kandoma, that there was no breach of any waiting custom between it and Kandoma. Rutamu also claimed that it actually objected once to that stupid culture by writing to Kandoma, advised the party. Can I get a volunteer to answer this question? So what exactly is the legal issue? Can I get volunteers? Volunteers? I have heard, and I've really never had the chance to listen into the tutorials of others, but I've heard that most of my colleagues have a more directive approach to tutorials in the sense that they ask the questions, then they provide the answers. I'm hoping it doesn't have to be that way. What I'm hoping in my tutorials is that students are forced to think about the problem, and for them then to attempt to answer the problem instead of everything having to come from me. So it can be a bit uncomfortable for some of you or for most of you, but I would think that your level of understanding will actually be higher if you think about the problem and attempt to answer it instead of just getting the answer from the lecturer. Because I think, if you're just listening to the answer, it doesn't really provide you an opportunity much to think about the problem and grapple with it. Okay, so from Samantha, would it have to do with jurisdiction? Meaning, would Kandoma have jurisdiction to try the Rutamu staff or whoever they may be? Okay, that's partly it. But in relation to international law, what is the broader question here? The broader international law question.
Manjo.
Yes, good.
I think we're looking at an international custom.
Okay. So phrase that.
And the source of the law that exists here would be an international custom, because there has been, since time immemorial, both states have recognised that a constant and uniform usage and in such a manner that it becomes binding, even though there is no treaty or anything like that. This comes from Section 38.1 of the ICJ, the sources of international law.
Okay, thank you. Right. So if you were to state the legal issue, what is the legal issue here? So you alluded to the rules, particularly to the sources of law. But before we get there, what exactly is the legal issue?
Is there any law that prevents that activity of, just ignoring the custom?
Okay, good attempt. Very good attempt. I'm not satisfied with that. Either you can go on, to try to state the proper legal issue, or somebody else may want to engage and, contribute to the tutorial. Thank you, Rice. But you're very close. Okay, here we have from Adrian. The issue is whether the consistent practice of states in the past can constitute an international custom. So there we go. So the question is whether or not there is an international custom that obliges states, in particular Kadoma and Rutamu, to ensure that that one fishing vessel from one state should wait a distance away until the first had left before that vessel enters the river, the mouth of the river. So that's good. That's correct, Adrian. Thank you. So that is the legal issue, whether or not there is an international custom. Well done. Thank you. Now, what is the rule concerning international customs? So we're trying to follow the IRAC format here. Okay, so we've began by identifying the legal issue, which is good. Adrian has provided that for us. Now, what is the rule concerning the creation of international custom or customary international law? Volunteers?
Yeah, it's Reese again.
Rice, yes. Did I pronounce it? Is that Rice or Reese?
It's Reese.
Reese, sorry, Reese. Okay, Reese, thank you. Go ahead, please.
Well, in Colombia and Peru, the asylum case, it was said that the state practice must be in accordance with a constant and uniform usage practiced by states in question in such a manner that it has become binding on the other party. So that there's two elements that really need to exist. That there is a general and consistent practice by the states, and that it is accepted as law, or one that is legally obligatory. It can't just be a practice that is done out of habit or general usage.
Very good. So not only must there be consistent and constant state practice, there is a requirement of what is known as the opinio juris. So a state is undertaking a specific behavior because a state feels bound to do so. In the absence of the sense of legal obligation of the opinio juris, then you cannot have an international custom. Very good. Thank you, Reese. So we've discussed the legal issue. We've discussed what the rule is. Now, applying the rules to the facts and going back to the legal issue, is there an international custom that obliges Kadoma and Rutamu for its vessels to wait at the mouth of the river if one of the fishing vessels of the other state is actually already inside the river? Is there an international custom? Okay, can I get a volunteer? Volunteers, what do you think?
I think yes, there is. Manjo?
Yes, go ahead.
Well, it meets the two criteria. So from time immemorial, they've been practicing this, and it does seem to be more than just it seems to be accepted as a law of practice to prevent accidents and the like, and it's generally practiced by both states, and it's accepted as a legally binding law, I think, for a significant period of time. So I think applying that to the facts here, I think there is established an international custom.
Okay. Now, the question here is, assuming that you can actually cite consistent state practice, which appears to be here, how can you derive that notion of opinio juris? How can you claim or argue that this practice, the consistent practice that seems to have been undertaken by both states, is actually out of a sense of legal obligation? And what if it is simply not out of a sense of legal obligation, but because to them it makes sense? It's good neighborly practice. What if that's the claim? Or can you actually deduce opinio juris on the basis of consistent state practice, so that in that case, the moment there is consistent state practice, you are necessarily saying that there is opinio juris. So in that case, they're one and the same. Is that the way we look at the creation of international custom?
Yes, I think so. So once you have the subject element of opinio juris, it can be adduced from the consistent state practice itself.
Okay. Thank you, Reese. Any other comments? Dissenting opinion? Comments? So we've got an answer from Samantha. Because of the commercial value, I think it is general and consistent state practice. Okay. So what has to be clear as far as the creation of international customary law is concerned? And here we're dealing with a regional custom. In fact, we're dealing with a bilateral custom. It's just between two states. Okay. So because it is just between two states, both states must have felt obliged to perform a certain state practice. Now, what is crucial in international law is that consistent state practice is treated differently from opinio juris. They're not the same. So just because you have consistent state practice doesn't necessarily mean that the consistent state practice is a result of a sense of legal obligation. So in other words, there is a burden of the one that claims that an international customary law has been created. That state must be able to prove that the state practice is in fact a result of a sense of legal obligation. So consistent state practice by itself is insufficient. There has to be proof that the state practice is a result of opinio juris, sivi necessitatis. In other words, it has been undertaken because there is a sense of obligation. The problem, as I see it here, is that it seems to be undertaken because it's as a result of, it makes sound sense, commercial sense, that we do this. It could be a sense of courtesy. But if it is because of courtesy, a sense of courtesy, a sense of proper commercial behavior, that kind of practice or behavior is not therefore a result of a sense of legal obligation. So that is the problem. So in other words, the key point here is that do not do not come up with a conclusion that because of a consistency of state practice, necessarily there is a sense of legal obligation. For example, and I'm going to give an example in ordinary life. Okay, if you were to buy food from Hungry Jack's, if you were to order food and you follow a line, you will notice that customers are observing a consistent practice in doing so. But are they doing it out of a sense of legal obligation? Obviously not. Okay, so the mere fact that there is consistency in state practice is insufficient for there to be a claim that there is now international customary law. So there is a need for proof of the element concerning opinio juris sivi necessitatis. Okay, so in this case, I would argue that the bilateral international custom between Condoma and Rotamo has not really arisen, because if it could actually be easily argued that both parties observe that state practice not out of a sense of legal obligation, but because they sense that was the best way to deal with that subject, either out of courtesy or out of commercial reasons, or using the phrase of Adrian Sotelo, it's because it's common sense. But just because you do it doesn't mean it's out of a sense of legal obligation. Okay, so there's that requirement. It has to be, you're doing it because there is a sense of legal obligation. Now, moving further, what about this claim that, so Rotamo was also saying that it actually objected once to that stupid culture by writing to Kandoma. In raising this actual objection, what is Rotamo trying to say? What legal principle in public international law is it trying to raise when it raises the point about its objection to a stupid culture? What is it? Do you remember? What do you think? Okay, so it has something, so I was trying to wait for somebody to write something there. Nothing has happened so far. It has something to do with what is known as the persistent objector rule. So there seems to be a theory in public international law that if a state persistently objects to the creation or development of customary international law, then that specific state cannot be bound by the international customary law. Okay. What do you think about that? Okay, we're kind of running out of time. The answer here is that the persistent objector rule would typically arise in relation to perhaps to a regional customary international law or a general customary international law. But here we're talking of a bilateral customary law between two states. And because it is between two states, the persistent objection is even unnecessary. Because it's easy for one state to just say that it does not recognize a state practice as legally binding. So the notion of being a persistent objector would usually be in relation to a regional customary international law or general customary international law. But even then, there are some commentators which question that possibility, although that has been recognized as a possible way out in the case of the North Continental case involving Norway. But in general, it is difficult to actually foresee. It can be quite difficult in most cases for a state to opt out of the development of customary international law on the basis of the persistent objector rule. In fact, that's what the point of Abbas is. Because the idea of the creation or development of general customary international law is that that becomes binding on all or most states, even to those states that have not engaged in the practice. Because the idea behind the development of customary international law is that most states are actually engaging in that practice because they believe it is legally obligatory on them, and there is no requirement that there has to be unanimity or a consensus of all states. It is sufficient that it is generally accepted by states that a particular state practice should be consistently followed out of a sense of legal obligation. Okay, so let's move on. Questions? None? Okay. Question 2. And we're going to go back to discussion question 1, actually, one of the other questions here. Again, going back to the customary international law. Now, in the 1980s, over 40 states signed a treaty. So going back to question 1, you will notice there that we kind of talked about the idea about consent of international law. So it would have suggested, the answer to question 1 would have suggested to you that international law is not necessarily based on state consent, not always, because it is possible for a state to be bound by international law on the basis of the actions and practices of other states. Okay, and we're going to see that in question 2. So in the 1980s, over 40 states signed a treaty that prohibited the dumping of hazardous waste by ships in the high seas. In time, most states respected this practice and prohibited the ships that flew the respective flags from dumping hazardous waste in the high seas. In 2013, it was discovered that the ships of the state of Sandorio were dumping hazardous waste in the high seas. The ambassador of the state of Sandorio was summoned by the Foreign Affairs Secretary of the state of Mauritania in order to complain about the dumping of hazardous waste in the high seas by the ships flying the flag of the state of Sandorio. The state of Sandorio's ambassador, however, demurred and explained that his country could not be held liable under the treaty because it was not a signatory to it. Advise the parties. Volunteers. What do you think? What's the legal issue? Volunteers? See the legal issue, what do you think is the legal issue, and then the rules.
Hello, Manjo.
Yes. 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 Yes.
Hi. So is the legal issue whether or not a country can be held accountable to a treaty that they've not signed up to?
That's partly the legal issue. What's the broader legal issue? Because actually the answer, wait. Is being echoed? Okay. In fact, I wouldn't think that that is a good way of framing the legal issue, because I think the answer would simply be no. How can a state be bound by a treaty of which it is not a signatory? There is a broader question. There's a broader legal issue. What might that be? But it's quite related to the way that you phrased it, Megan. What might that legal issue be? A broader legal issue.
Manjo, I can't get it.
Okay. Others? Thank you, Megan. Others? Okay, so to me, the broader legal issue is in fact whether or not there is an international law that prohibits states from dumping hazardous waste in the high seas. That is the legal issue. Whether or not there is an international law that prohibits states from dumping hazardous waste in the high seas. Now, you will notice that that question is broader, because by citing the phrase international law, you're actually saying that the source of that legal obligation concerning the prohibition against the dumping of hazardous waste can be because of a treaty, could be because of customary international law, could be because of a general principle of international law. So, going back to the question then, is there an international law on the basis of the facts that prohibits the dumping of hazardous waste in the high seas, which would then bind the state of Sandorio, even though it was not a party to the treaty? What do you think? Volunteers? Volunteers.
So, Manjo, did I pretty much jump to the rule rather than the issue?
Yeah, you did. So the point about identifying the legal issue properly is that if you notice, if we had defined the legal issue simply to be whether or not the state of Sandorio can be bound by a treaty, even if it was not a party to it, meaning even without its consent, then simply your discussion of the rule will simply be in relation to whether or not a state can be bound by a treaty, even if it is not a signatory to it. And obviously, when you apply that rule to the facts, the answer is no. Because if you speak of being bound by international law on the basis of a treaty or international convention, it has to be based on consent. So that's the problem, okay? So there is a reason why you need to identify the legal issue correctly, because the legal issue, actually, the identification of the proper legal issue actually enables you to determine what rules are relevant, what rules need to be cited in order to answer or address the legal issue. So if you define it wrongly, if you've incorrectly identified the legal issue, you will end up with a statement of the rules or the law, which actually does not come up with a proper answer or does not address the legal issue. In which case here, had we focused on the treaty, we would have come up with the wrong answer. Because the basic question is, can there be a way for the state of Sandorio to be bound by international law, even if it were not a party to the treaty? That is the bigger, broader question. Okay. So if you follow the treaty, we say that it can be bound by a treaty because it is not a party to it. The question, though, is, could international customary law have arisen or have developed, which would then bind the state of Sandorio, even if it were not a party to the treaty? In other words, the question is, can customary international law evolve out of a treaty so that even those who were not original parties to the treaty can be bound to customary international law that evolved from a treaty? That's the question. What do you think? Answers? What do you think? Do you think? Okay, so we're kind of running out of time, so I'm gonna have to provide the answer. I'm hoping I didn't have to. Okay. Okay, so it is possible for customary international law to arise from a treaty. So that should be clear. Okay, so in other words, it is possible for a few states to engage in particular practice on the basis of a treaty, but through time, other states which were not parties to the treaty observe that state practice as contained in the treaty as well, and in coming up with a consistent, constant, regular state practice which emanated from a treaty, and that practice is on the basis of a sense of legal obligation, then there is the development of customary international law, which would then bind states which were not and which were never parties to the treaty. So customary international law can develop from a treaty. Now, therefore, in relation to this, it can be argued that, as we said here, in time, more states respected this practice, and they would have done so, it could be argued, on the basis of a sense of obligation, because they know that the dumping of hazardous waste in the high seas is actually detrimental to the rest of the international community. So that practice, observed consistently by states, was actually as a result of a sense of legal obligation. So that only was there consistent state practice, but there was opinio juris sive necessitatis, that there was a sense of legal obligation in when the states undertook or observed this state practice. And because of that, it would not have prevented the development of customary international law, which would then bind the state of Sandorio, even if it were not a party to the treaty. So in that sense, therefore, if we could argue that customary international law, which prohibited the dumping of hazardous waste in the high seas, has been created, it would then bind the state of Sandorio, which means, therefore, that that country could be held liable under international law, particularly under customary international law. Clear? Okay, let's move on to the next question. Okay, this one. The ambassador of Nirvana to the state of Guanaland was summoned by the state of Guanaland's Secretary of Foreign Affairs, SFA, to complain about the failure of the ambassador to bow before the king of Guanaland during a diplomatic meeting. The Guanaland's SFA claims that there is a consistent practice among states that people, including diplomats, should bow before monarchs and kings. Hence, he claims that there is a customary international law on the matter. Assuming that there is such a consistent state practice, would the SFA be correct? I've seen a comment from Samantha. I'm just going to go back to that in a short while, Samantha. But let me just focus on this particular question first. What do you think? Would the SFA be correct? Can I get a volunteer? And so this is kind of related to the first discussion question we have. Okay, so we have an answer. Well, we've got a statement here from Adrian. There would be multiple appropriate greetings for king's leaders all over the world. Okay, and what does that suggest to you, Adrian? So he says, I guess no. But what are you saying? So the fact that there are multiple ways of greeting kings and leaders all over the world, what does that suggest to you?
Can you hear me, Manjo?
I can hear you. Is that Adrian?
Okay.
Yes. Go ahead.
Yeah, this is Adrian. Sorry. Yeah, so I'm assuming that like so many common greetings that differ all over the world would kind of imply that there is no common one in relation to one specific area.
Yes. That's one. So obviously, if there are different ways by which states practice this, then it's difficult to speak of a consistent regular state practice. That's one. What's the other element that's crucial as far as the development of customary international law is concerned? What's the other one?
That there's a law related to that?
No. What's the other aspect there about the development of customary international law?
It needs to be more than mere habit or usage.
So what exactly is it?
It's just habit.
The opinio juris has to be there.
And it's not in this case.
Yeah, there has to be that sense of obligation. So you will notice, for example, when there's the Pope, right? So you will notice sometimes that when a president of a country meets the Pope, the president of the country will kiss the Pope's hand. It's difficult to argue later on that there is a international customary law has developed so that when a leader of a state meets the Pope, that the leader of that state has to kiss the Pope's hand. Or even the question of bowing before a king or monarch. That's not because there is a sense of legal obligation. It's simply probably out of courtesy. Okay. So what you need... Yes?
It was Queen at one stage.
Sorry, I missed that. What was it?
Prime Minister Paul Keating was touching the Queen's back at some stage, and it was in the news as being something.
Yeah. I remember that. So assuming that happened, somebody touches the back of the Queen, or was it the Queen you mentioned, would there have been a breach of international law? What do you think?
Not necessarily, no.
Go ahead, Peter. Why not?
Well, it's got to go beyond that. It's got to go beyond that, and I'm trying to explain myself. I'll come back to you later.
Okay. So states, in that case, there might be a norm of behavior out of a sense of decency, but it's not because there is a legal obligation. So that kind of, a norm of decency, for example, is not a source of international law. It's not in Article 38 of the ICJ statute. So what is crucial, therefore, is that you need to be able to show not only consistent state practice, but that consistent state practice is a result of a sense of legal obligation, meaning there's the opinio juris. In the absence of the opinio juris, you cannot have the development of customary international law. Now, okay. I kind of saw something about general principle of law here. In general, it's general practice. Okay. Mm-hmm. From Samantha. Okay, not breached international law. Right. Okay. So we're good. Now, we have time. I'd like to go back to the point raised by Samantha, and this goes back to question 2. Would it be valid to look at whether the other states are still following the general principles that are recognized by the states in the treaty? Now, there are 2 aspects to that question. So let me repeat the question of Samantha. And this goes back to question 2 earlier, not this particular question here. Would it be valid to look at whether the other states are still following the general principles that are recognized by the states in the treaty? Okay, so earlier in question 2, we had said that customary international law prohibiting the dumping of hazardous waste at the high seas would have developed. So we would have had customary international law. In relation to the development of customary international law, Samantha asks whether or not we should look at whether or not other states are still following it, which means therefore they were following it but no longer are. Actually, the legal issue there is, can international law therefore be changed on the basis of some states no longer adhering to customary international law? Did you get the legal issue? So there has now been customary international law, which we agreed exists on the basis of consistent state practice and opinio juris. And that there is a customary international law in relation to question 2 that prohibits the dumping of hazardous wastes in the high seas. The question is, can that customary international law then be changed, or could that have been abrogated on the basis of the practice of some states in not following customary international law? Actually, the point one is, would those states that failed to follow customary international law, the basic question is, would they have not been in breach of a norm of customary international law? That is the basic question. Okay? So the answer is likely they would have been in breach. Now, secondly, the other point that we need, as a matter of rule of international law, the other point that we need to realize is that it's obviously possible for states to change customary international law. Why not? They could change it. But for the change to happen, it must have been engaged by most states. So in other words, if you have a few states trying to change customary international law, what would happen is that customary international law cannot be changed by a few states. In fact, these few states that would attempt to change customary international law would be in breach of international law, in particular of customary international law. So once customary international law is in place, because it has been created by consistent state practice by most states, and it was a consistent state practice that was based out of a sense of legal obligation for one state or a few states to then try not to follow the customary international law, those states would be in breach of customary international law. So it's difficult, in other words, to try to change it. It can be changed, but it won't be easy once customary international law has developed. Okay, last question. Okay, the Paris Agreement on Climate Change entered into force on 4 November 2016 upon its ratification by 109 of the 197 parties to the United Nations Framework Convention on Climate Change. Under the agreement, the parties commit to reduce their respective greenhouse gas emissions according to specified targets. Although the state of Catalonia is not a party to the Paris Agreement, it has increasingly been under pressure to reduce its own greenhouse gas emissions. Considering that perhaps only less than 3% of the states of the world are not yet parties to the Paris Agreement, it is now claimed by some that the duty to reduce greenhouse gas emissions has now attained the status of customary international law and binds the state of Catalonia. Advise the state of Catalonia on the matter. And you will notice this question is kind of related to question 2, I think. Yeah, question 2. What do you think? Advise the state of Catalonia on the matter. Volunteers? Volunteers? Okay. So the legal issue really here is whether or not the customary international law has developed to such an to the point where states are under obligation to reduce their greenhouse gas emissions. That's the question. Okay, because what we're saying here is that whether or not the state of Catalonia, who is not a party to the treaty, can be bound under customary international law. So the question is, could customary international law have arisen, which then binds non-parties to the treaty to reduce their greenhouse gas emissions? So that's the legal issue. And so we know the rule about customary international law. And one of the rules of customary international law is that there must be consistent state practice, and two, there must be a sense of legal obligation. Okay, so that's the rule. Applying the rule to the facts, the fact exists. The fact as it is that, one, there has not been a consistent state, and we're talking of a particular specific treaty here, a real treaty, which is the United Nations Framework Convention on Climate Change. There has not been consistent state practice regarding climate change. Okay, some states have not attempted to reduce their greenhouse gas emissions, in particular the United States. It was only this year that the United States signed the Paris Agreement. So it has begun to be bound by the requirements concerning greenhouse gas emissions, but because of the treaty. So the first problem we have is there's a lack of consistent state practice. Okay? And in fact, if you examine the United Nations Framework Convention on Climate Change, there is no legal obligation on the part of the treaty signatories actually to reduce their greenhouse gas emissions, not under the UNFCCC. So they will make their best efforts to try to reduce their greenhouse gas emissions. And there is certainly no requirement that it has to be a certain percentage. So therefore, we have a problem. There is no consistent state practice. And for those states which attempted to reduce their greenhouse gas emissions, including, for example, Australia, because Australia did commit to reduce its greenhouse gas emissions under that treaty, in many cases, it was not because of a sense of legal obligation. It was more because they felt that it was something that they owed to the world, not because of a sense of obligation, but it was kind of a good practice. So you have a problem, therefore, in relation to this. You cannot have customary international developing because of an absence of state practice, consistent state practice, as well as the absence of opinio juris. And so compared to the discussion question 2, therefore, you will notice that the discussion question 2 in relation to the dumping of hazardous waste had a specific state practice. The state practice that had evolved in that example was the non-dumping of hazardous waste in the high seas. The one about the climate change is actually more complicated, because if you examine the United Nations Framework Convention on Climate Change, there are so many provisions there, multiple rules, so that at some point it's difficult to complain that somebody has violated the United Nations Framework Convention on Climate Change. And in fact, there is nothing obligatory there. It's actually more of best efforts on the part of states. Okay? And remember, at this point, we're talking of an actual treaty. Okay? So there is no specific legal obligation on the part of any state to comply with any specific treaty provision. So that assuming that a state, in fact, kind of violated a treaty provision, it would be difficult to file a complaint against it. Because, again, as I said, the particular treaty is not really clear on what can be done. So that, in a sense, it's more of a declaration, more of a desire on the part of states to do this. So because it's a sense of a declaration, more of a desire, there is no sense of legal obligation, which would then prevent the development of customary international law. Okay. Questions before we end tonight's tutorial? Questions? Are you still there? Or am I the only one speaking here? Okay, so the participants are still there. Questions? None? Okay, so I guess we could end tonight's session. So again, thank you everyone for joining tonight's session. I thank you, Reese, Megan, and Samantha, Adrian, for participating. And in case I failed to mention anyone else, thank you anyway. And so I hope to see you again next week. And thank you.
Thank you, man.
Thank you. Good night, everyone. Oh, thank you, Oloyume as well. Thank you. Good night, everyone.
Good night.
Good night.